Good morning. Again, this is our Title VI Civil Rights Responsibilities for CCE, and I've listed the organizational development team who deal with program and professional development and civil rights and diversity and inclusion work. It's myself, Sarah Dayton. I'm Assistant Director of Extension, and my area is organizational development and accountability. Kim Fleming is our Professional Development Specialist. Eduardo Gonzalez is our State Diversity, Research Partnership Development, and Youth Development Specialist. And Celeste Carmichael is our Program Development and Accountability Specialist. And each of us has a role in supporting the work that you do. And so I will mention each of us and our roles throughout the presentation, just so you know where you might tap into each of us for particular support. Please note that on the bottom of my slide, we have our statement. Cornell Cooperative Extension is an employer and educator recognized for valuing affirmative action, EEO, protected veterans and individuals with disabilities, and provides equal program and employment opportunities. And that is part of our responsibility in informing the public. And so this information is on our slides and should be for public presentations. Today, we'll be reviewing Title VI Civil Rights Basics. We'll cover some of the resources that are available to you, and there will be time for questions and answers at the end of the presentation. Please note that I am very specific about saying that this is our Title VI Civil Rights Basics. The reason I do that is that in our last audit in 2009, a number of people referred to having diversity training, and there's actually a distinction between civil rights training, which is about the legal foundation, and then diversity training, which might be built on that legal foundation. And when the auditors came from Washington, D.C., they were very specifically looking that we had that foundation in the laws training, so that's our Title VI training. So I'm repeating it because it's an important one to keep in our heads. All of the training is really good and really important, but that is one that we might get specific questions about. And again, please use the chat box for questions. I've muted all the participants, and sometimes if you're getting feedback or anything, it can help if you're on the phone to mute your computer speakers. In 1963, President John Kennedy was very concerned about civil rights, and as were many people, and not just the president, certainly. One of his statements, which really captures it for me, is that simple justice requires that public funds to which all taxpayers contribute not be spent in any fashion which encourages, entrenches, subsidizes, or results in discrimination. That fundamental belief that if we're taking money from people, they should have the same rights and access and benefit from that money and the spending of that money as any other person. So the overview of Title VI in the Civil Rights Act of 1964, initially Title VI was enacted as part of the landmark Civil Rights Act of 1964 and prohibited discrimination on the basis of race, color, and national origin in programs and activities that received that federal financial assistance or those tax dollars. And if you're interested, there is certainly lots and lots of information available on the federal websites. The core message for today is that an organization that receives federal dollars, whether it's a grant or an allocation or a contract, it has a responsibility to ensure civil rights compliance. And sometimes people say, well, my particular organization doesn't really receive very much funding. You know, at what point does that obligation kick in? And the obligation actually kicks in when you receive more than $0. So if you get a single penny, you're in. And Norman Pruitt, who did the audit last time, came in, and he's a wonderful gentleman and very committed to his work. And he sort of describes his work, and he said, if you got a penny, I'm going to find where that penny went. I want to know it was used properly. And so he's a super guy, but he was talking to Helene going, I want to know where my penny went. And actually, it wasn't his penny, it's our penny, so all the difference. Okay, so with the obligations, that creates obligations around understanding civil rights, being aware of it, and promoting civil rights and upholding them. And along with that comes spending requirements and restrictions on certain things that the organization can do. And it also creates a responsibility to do reporting. And so that's a place where we think about the work that Celeste does, because she manages the federal report for the system. So what if an organization decides, we really don't believe in this, or we really didn't get that much money, or it sounds like it's a lot of work, or we don't know what to do, or we in fact don't believe in civil rights? If a recipient of federal assistance is found to have discriminated and voluntary compliance cannot be achieved, the federal agency providing the assistance should either initiate fund termination proceedings or refer the matter to the Department of Justice for appropriate legal action. And so what they're saying is the first thing that should happen is you withdraw those funds if you cannot get voluntary compliance, and it may need to be referred to the Department of Justice, and there are criminal and civil penalties, so financial penalties, and even jail time for people who have discriminated against individuals. Obviously fairly serious. In some cases, certain states or certain organizations that did not comply with civil rights actually found the courts overseeing all of their actions, including every single hire that they made, had to be reviewed by the court system to make sure that they were doing everything they could to not discriminate. And certainly the opportunity for lawsuits and fines, things like that. And let me just say, Cornell Cooperative Extension, we have a very positive reputation at the federal level. And certainly everything that I've ever seen within Extension is all of us working really hard to figure out how to do the best work that we can and make sure that we are inclusive as we can be. So this is really the other end of the spectrum out there in the world with organizations that are actively having problems. That's not us. Okay. And so how does the USDA ensure organizations comply? They have two primary approaches. One is education and information, so they directly provide education and information to the public. They do listening sessions, they have a website, they have phone lines, you can call in and ask questions. And then the other way that they do it is indirectly, and that would be through organizations like ours that are required, because we're recipients of federal funding, to also do outreach about the civil rights compliance and our role and responsibility. So we train ourselves, and then we also share information with the public about our approach on the work that we do. In addition to education and information, the federal government also monitors. So they do the annual federal reporting. So again, the work that Celeste does to pull all of your work together, that is reviewed closely. It also incorporates, when we turn in data for the audit, they also look at all of our hiring records, who was promoted, who was let go, all of that information, also looking at the employment side, so that's part of the monitoring. They do random civil rights audits. So if someone, as you see there, complains or there's a lawsuit filed, that may trigger an audit. Typically, though, and quite frankly, all of the experience I have in Extension and the work that I've seen in Extension is that typically what you see are the routine federal audits. I've never seen a random civil rights audit coming as a result of a complaint, but I have fairly limited experience, only 8 years here, and I personally sort of keep an eye on what the other states are going through. I know there have been audits triggered by a complaint, but not in our region. USDA Regulation 7 CFR 15, that's the Code of Federal Regulations, stipulates that any recipient of federal financial assistance, regardless of the amount, is subject to civil rights reviews. So that's like that audit I was talking about. The language is actually that it's a review. Feels like an audit, though. Okay. Further, the primary recipient of federal financial assistance is responsible for civil rights administration, where the primary recipient has extended the financial assistance to another recipient. So this includes any funds that you share, space that you share, staff that we share, providing support to other organizations, everything that's supported by federal dollars. And realize the associations don't, each association gets a small chunk of money in federal dollars distributed from Extension Administration to the association, but also everything that's done on Robert's third floor, so all of our payroll, all of the HR, finance, IT, the director's salary, the assistant directors, we're all supported by federal dollars, so this entire system is considered to be touching federal dollars. So sometimes it's people try to think maybe it only applies to part of us, but it actually applies to every part of us. So what does it mean, a primary recipient, another recipient, you know, what is the path there? So each level has a responsibility for itself and the next recipient. So Extension Administration is responsible for its own civil rights compliance, but we're also responsible for the association's civil rights compliance because we pass those federal dollars on to you and because those federal dollars support the system. Then in turn, the association may pass those federal dollars on, or the staff time or your space, you pass that on to your collaborators or the groups that you work with or program participants or volunteers. So it means that we're responsible to ensure the civil rights compliance to the extent that we're able to of the other individuals that are sort of in our circle, which means if you're offering a program and you see two participants violating each other's civil rights, we have an obligation to step in and disrupt that interaction, to stop that interaction, or even to stop the program if we can't control the particular situation. And we certainly have had things like that where it might be just two participants not really realizing, you know, they're getting into a bit of an argument or something. It is the obligation of our organization to intercede in that situation. Any questions there? That's kind of a big statement. I'll pause and see if anything comes up in the chat box for just a moment. All right, guess it was pretty clear. Okay, and certainly I'm here if you ever have questions, just an email or a quick phone call is fine. So with Title VI Civil Rights Basics, federal dollars equal that civil rights obligation. So this expectation that we have a basic knowledge of the civil rights laws, that each of us understands and follows the policy of non-discrimination in our work, that we notify, as an organization, we notify the public of our obligations and their rights, and that we offer equal program opportunity, that's Title VI, which we're covering today, and we offer equal employment opportunity, that's Title VII, which is covered by HR and our HR leads and our local HR people, and that we as an organization have a complaint procedure, and we do. So the obligation extends from the USDA stream of dollars. So I'm being very specific because each organization, their obligation goes back to the organization that they received the money from. So for us, it's the USDA, and that applies to Cornell Cooperative Extension, the New York State Agricultural Experiment Station, the Cornell University Agricultural Experiment Station, College of Human Ecology, College of Ag and Life Sciences, and the Veterinary College. And then, of course, any of our subsequent recipients. Realize that the university receives federal dollars through grants, contracts, all sorts of things all over campus. So other units may have other entities that they report to on their civil rights compliance. Cooperative Extension and the other units that I mentioned, we all report to the USDA on our civil rights compliance. But we also may have, especially faculty may have multiple funding streams, and they may actually report to multiple funders. Okay. So the Title VI Civil Rights Act of 1964 provides that no person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in or be denied the benefits of or otherwise subjected to discrimination under any program or activity receiving federal financial assistance. And realize it was just race, color, and national origin to start, and then there were additions made to that law. And as I'm going through this, I will actually also mention some New York State laws that apply to our compliance in covering human rights and civil rights, so I will throw in a couple state laws. Title IX is the Education Amendment of 1972, and this addressed no discrimination on the basis of sex. And if you went to high school in the 1980s or 90s, you might remember, or even 70s, you might remember this being more applicable to women in sports participation, which is how I remember this coming around. If you're watching the local news, or the national news, I should say, you're probably seeing this more on the basis of sexual harassment. And for example, some of the unfortunate examples that we've seen reported in the news lately on college campuses and violations of women's rights on college campuses, sexual harassment and sexual assault, many of those things are starting to fall under the Title IX. I shouldn't say starting, they fall under Title IX, but it's something that's getting a little bit more press these days. Right. The Rehabilitation Act of 1973 was a law addressing the concern about discrimination on the basis of disability, and very specifically, no discrimination in employment, programs, access to electronic and information technology. And it's a complex law. I really have just a few little pieces of information here. The Rehabilitation Act prohibited discrimination on the basis of disability in programs conducted by federal agencies or receiving federal financial assistance in federal employment and in the employment practices of federal contractors, so those receiving federal contracts. The standards for determining employment discrimination under the Rehabilitation Act are the same as those used now in Title I of the Americans with Disabilities Act. So it was saying you shouldn't discriminate. And here's where I remember that I was supposed to switch these slides because I don't like the order, so I'm going to jump ahead and then we'll go back. The Americans with Disabilities Act of 1990, and as amended, and this has been amended a number of times, went further than just the Rehabilitation Act. It said not only can you not discriminate, but you actually have to actively get out there and figure out how to reduce barriers. So the Americans with Disabilities Act gave civil rights protection to individuals with disabilities that are like those provided to individuals on the basis of race, sex, national origin, and religion. It guarantees equal opportunity for individuals with disabilities in employment, public accommodations, transportation, state and local government services, and telecommunications. And cooperative extension and the work that we do is very clearly covered under this area. Let's pop back one slide. Age Discrimination Act of 1967, ADEA, is a federal law providing a broad ban against age discrimination in hiring, promotion, wages, termination, employment, and layoffs. I think the cutoff was 40 for that law. New York State law goes beyond that, so it's important to understand that New York State, we have even a stronger law, and that law provides additional protection for employees over the age of 18. And some of you, especially those of you working in the New York City area, may have even further laws, so that would be important to be aware of and work with your HR people in those local, because they're very specific local things. But local laws may provide even further protection. So to spend a moment on ADA accommodations, and looking specifically at program, I just want to spend a minute to talk about that. There's another presentation on this if people are interested in delving into it further as far as a presentation. If you have a particular situation where someone is asking for an accommodation, I'm available for you, as well as the HR team and your HR leads throughout the state, to help work through ADA accommodation requests. They can be kind of tricky, and it's something we feel really strongly about. We want to be really good at it, but each person and each situation is individual, and so it's important to take the time to work with individuals and understand what their specific needs are. CCE is obligated by law to offer reasonable accommodations unless it causes undue hardship to the organization or would fundamentally alter the nature or the operation of the organization or program. These are very, very high thresholds. Sometimes people will say, well, if I had to offer these accommodations for my Master Gardener program or my 4-H program, it would just decimate my 4-H budget or my Master Gardener budget. The federal government doesn't assess the cost of that accommodation against your specific program area. It actually assesses it against the association's entire budget. And so what looks really big compared to your immediate budget might be smaller against the association's budget. And so we want to be super careful. As I said, it's individualized, it's case-by-case basis. So we would never want to say, you're blind, this is what we do for blind people, you're deaf, you have hearing impairment, this is what we do for hearing impaired people. It would, I mean, I'm being facetious, but we would never want to say this is what we do for this particular situation. It's always about what that person is experiencing and what they perceive their needs to be. And it's true, there are going to be times where the accommodations that they request are beyond the scope of what extension can do, what an association can do. And we've had examples where people say, well, you're like the public school, you have to do everything for us. And it's very different from a public school system, but we do definitely have an obligation to help. And in truth, from the research and the reading and the discussions that I've had with experts in this area, over 95% of the types of accommodations that people need are almost no cost. So the key is to really understand what people need and figure out creative, reasonable ways to meet their needs. So no is a very scary word, and I've had associations, especially when we first started working on this, feel like if it cost anything or they had to do anything, they didn't have any experience, and they were like, no, we just tell people we can't do it because we don't have any money. No is a scary word because it can trigger a pretty quick complaint, and the complaint can go to the Department of Justice, it can go to the USDA, or it could go to an attorney, and it's really tough to justify an absolute no. So I say no is a scary word. We really should try to avoid ever using it. If someone is asking for an accommodation, it's always how can we figure out a good path to this. Negotiation is really important, and it's important to get support because it has implications for the individual. We want them to be able to participate in our program, but it also has implications, both legal and potentially financial implications for the association. So we definitely want support. As I said, you have your local HR people, your HR leads are highly skilled in this, and then I am also here for you. And we've had some really nice examples over the time that I've been here. Lots of really good approaches, creative approaches to helping people participate in a comfortable fashion in their programs and get benefit from their programs. It is important to think about the nature of the program and what the person might need. So many years back, we had a youth in 4-H participating in multiple programs, and in some of the programs the youth participated, the parents came and translated because they knew sign language and used it with their child. In other examples, there were notes used, so a note taker was used, the youth could read, and so that worked perfectly. And then there were also some examples where the youth was participating in shooting sports, and because of the high-risk nature of that particular activity, there was actually a licensed interpreter who was hired to do interpretation for that particular participant for that program because of the risk. And we can never charge a participant who needs an accommodation for the cost of that accommodation. It can never be charged to the person. You can, however, increase the participation costs of the program to everyone, and you can use that money to support the accommodations. But again, we cannot charge people for their accommodations. So there is a form on the website, on the organizational development website, and I think it might also be linked to the HR website just in case people stumble upon it there. But it is a nice little form to help you kind of walk through with a guardian or parent or participant and help understand their needs from their perspective. In general, you really want to avoid collecting medical information. You really want to keep the conversation at the level of you know, what is it that we might need to be able to help you? What kind of accommodation are you requesting? We want to avoid getting their personal medical information and their medical diagnosis or anything like that, because it can put us in another uncomfortable position of having to defend that we're not discriminating. So we really absolutely try to avoid that. You will get into certain situations. It's possible that someone needs a lot of accommodations. At some point, you may actually need a doctor's note to justify and provide foundation for the requests. But if you're in that territory, you really should be at that point working definitely with your supervisor, executive director, and an HR person helping you navigate that, because they can be kind of tricky waters, and our HR people are specialized in this area. Right? Executive Order 13166 covers limited English proficiency, and another area where the federal government has an expectation that we are doing reasonable accommodations is making sure that people who have difficulty with the English language for whatever reason, that we're not discriminating. So for this, we may have people who are Spanish speaking or another language and they need materials translated. This is an expectation of the federal government, and they take it really seriously. We have some fantastic examples across the state where certain associations have done a lot of work with certain immigrant populations and do have a number of materials translated. Realize that you aren't required to translate all of your materials necessarily. If you can find similar materials offered by, say, another extension state, it's perfectly acceptable. So, for example, if you need Spanish language materials and you can't find anything in your particular area, you don't have them in-house kind of thing, look at California, look at Nevada, look at Texas. There may be another state another state extension program that has materials that you can use. And I would say if you were willing and you find some really good resources and you want to share them, please let us know, either me, Kim Fleming, Eduardo Gonzalez, one of us, send us the links because we can add them to our website and help create more resources to be shared across the state. Any questions? Okay. This is a state law, Sexual Orientation Non-Discrimination Act, SONDA. It's a New York state law, 2003, and it prohibits discrimination on the basis of actual or perceived sexual orientation in employment, housing, public accommodations, education, credit, and the exercise of civil rights. So again, certainly New York State has been really at the front of the curve for the country, the whole country now. We have, we're working on federal level laws to protect people. So New York's in a really good place. Our associations have been leaders in this, in particular in our youth program. Youth programming across the state, we're seeing more and more young people self-identifying in ways that are not, you know, sort of the traditional ways. And it's something that we all want to work to be as comfortable as possible with. We do, again, have good resources, especially if you haven't personally experienced a whole lot of, and no personal experience with it. It's important to do some reading and get comfortable with it because it can be a shock to the system if it's just not, you know, it hasn't been part of your personal experience. But we do want to be as welcoming and as accommodating as we can. Executive Order 13672, so this is the federal level, prohibits discrimination in the civilian federal workforce on the basis of gender identity and in hiring by federal contractors on the basis of both sexual orientation and gender identity. So again, we're starting to see more and more laws in this area making sure that people's rights are protected. right? And so you will now see this incorporated in Cornell Cooperative Extension's policy of non-discrimination. Cornell Cooperative Extension has tried to stay as quickly responsive to the changes that are coming as we can. So no person shall be denied admission to any educational program or activity or be denied employment on the basis of any legally prohibited discrimination involving, but not limited to, such factors as race, color, religion, political beliefs, national or ethnic origin, sex, gender, gender identity, transgender status, sexual orientation, age, marital or family status, protected veterans, and individuals with disabilities. Cornell Cooperative Extension is committed to the maintenance of affirmative action programs that will assure the continuation of such equality of opportunity. And part of this, which I haven't listed here, is that there are also new laws that came into place. They started in 2013, they started being applied in 2014, and they are full force as of January 2015, which is the Office of Federal Contract Compliance Programs. So organizations, again, that get federal contracts, and this has added in a layer of protection for veterans and individuals with disabilities. So there was a request sent out earlier this year to enter your veteran status and if you were an individual with a disability, and that's a new level of requests that we're getting from the federal government about how well we're doing inviting, welcoming, and engaging individuals who are protected veterans or individuals with disabilities. Right. So in addition to what we've been talking about, we also have a federal requirement to notify the public of our policy of non-discrimination. So we include that statement of non-discrimination on our annual reports, on our program flyers, on our materials that we print. Maybe we may use a shortened statement, which is fine if you have limited space. So that policy of non-discrimination, I'm getting a little feedback, and I'm sorry, I'm messing with the, I was messing with the muting piece. All right, so this policy of non-discrimination applies to offering equal program and employment opportunity, that we have a policy for Americans with disabilities, that we have that limited English proficiency policy, and that we have a complaint procedure, and that's both for program and employment side. And that also we share the Justice for All poster. There is a link, I think I have a picture of it in the next slide. I want to come back to the, oh, I might not. All right, I'll have to put that in there. There is a Justice for All poster, and that actually incorporates all the language about the policy for non-discrimination, not our specific policy, our Cornell Cooperative Extension policy, but it has that the organization has a policy of non-discrimination, equal opportunity, ADA, limited English proficiency, and a complaint procedure. So that poster is one way of informing the public of our responsibility and their rights. And the value of that poster is you can print it off on your regular printer and just hang it up in any room where you have public engagement. So if people are coming in for workshops, just have one on the wall. If you have a public space where people meet, just have one on the wall. People who are going out and doing programs, it's not a bad idea to keep one with you. We've had educators who have taped it to the top of their laptop, so when they flip their laptop open, the poster is hanging down. And I know it might seem like a, you know, really do I have to carry a poster with me? But we've actually had one county where a federal funder, there was an auditor from a federal funder, and who came to a small workshop to check on their compliance, and they were written up for not having the poster up, and they were off-site. So again, super simple, take a paper copy and a piece of tape, tape it to your computer, have one with you. You just never know, and it's a small piece of insurance. Right? And Bonnie is asking, we keep getting questions about Boy Scouts asking for workshops, and how do we balance the non-discrimination of those participants based on their affiliation to Boy Scouts and the need not to program to another organization that does discriminate. So it's a really good question, and it's really, there's a couple pieces here. So Boy Scouts is an organization, it's a private organization, and they have chosen for themselves to have a policy which does discriminate at this point against adults who are gay. They cannot be leaders in the Boy Scouts. They have, and so, I mean, we have to be pretty impressed that they have changed their policy and incorporated that gay youth are now allowed to participate. But as an organization, they still have a policy of discrimination. And so you are right. This is an organization that we have to be careful in our interactions because we're extending federally supported resources to that organization. So the discussion around this and sort of the policy, I guess it's an unwritten policy because we don't really have a specific policy about Boy Scouts. We just have a policy of non-discrimination. So in order to carry out our policy of non-discrimination and not discriminate against those youth, we encourage the youth to come to programs just like anyone else. They are welcome to come to programs. The request is that they wouldn't come as a uniformed troop because that's uncomfortable, you know, that's disrespectful or at odds with our policy of non-discrimination. And think about, there may be youth or adults or employees who are engaged with that workshop who are gay, and we have to be concerned with their rights as well. So we want to welcome and encourage those youth to participate in our programs, but not as a formal troop. And the limitation would be that our educators would not go and do Boy Scout specific programming. So we would not program specifically and only for Boy Scouts. We would program for public events, we would program for youth events, but we would not want to put ourselves in a position of having to gone out and doing a composting workshop for the Boy Scout Troop 57. That would put us in a very awkward position and would be inconsistent with our policy on non-discrimination. I'm going to wait just a minute and see if anybody pops up with any follow-ups. Another aspect, sometimes people will say, well, now you're discriminating against Boy Scouts. And it does seem a little awkward that the approach to not discriminate is to discriminate. Well, it's really not a discrimination. Discrimination is against people. We're not discriminating against people. We're saying this organization has a choice, and it's fought all the way to the Supreme Court of the United States to protect its right to do that. And quite frankly, we should support their right. That's their choice. That's how they choose. And we don't want to impose on that. But at the same time, we want to make sure that we have access to the youth and make sure that the youth have access to our program so that they can participate. So Bonnie's asking, would we be held responsible if they show up to in uniform unexpectedly? And Bonnie, honestly, I don't know. I mean, I suppose, well, no. All right. And this is why I record these and then go, oh, I'm not using that recording. This is one of those moments. So you and even Cooperative Extension, I can't imagine that we would be held responsible if external people come to to our meeting and they're wearing uniforms. The expectation of you and the association would be to have a courteous side conversation with the leader and say, we're so glad that you came and we appreciate that you're interested in our programs, but I have to ask you, please, we have a policy of non-discrimination and we ask that you come as sort of civilians as opposed to your uniformed troop. And in that event, I actually would make a note to myself, or I would email myself and file that away to save in case it ever comes up that someone felt that, another individual felt that their rights were being violated by the Boy Scout troop being there in full force, kind of thing. So, and I just want to say, I have no ill will. I have only respect for Boy Scouts, the work that they do. I'm uncomfortable with their policies, organizationally, their policy is inconsistent with our policy, but in truth, I'm sure there are lots of people on this call who have been Boy Scouts, their dads have been Boy Scouts, their brothers have been Boy Scouts, their sons might be Boy Scouts. The organization as a whole does good work and does positive youth development, and there is a policy we're not comfortable with, it's inconsistent, but I don't mean in any way to denigrate Boy Scouts. So I hope that was a good answer, and I don't know if Kim Fleming's on this, and she's probably laughing right now, but I'm probably going to go, no, don't use this one. We're doing another one this afternoon. Okay. So in our responsibility to notify the public, I mentioned the importance of a complaint procedure. And so first of all, it's really, people complain. Sometimes we're like, oh, don't complain. We want people to complain. I would much rather have them tell us than tell other people. Because if they tell us, we can find out where we can improve and we can set something right where we might have made a mistake or an error. So in employment, each employee in the system, that you have your own employment complaint procedure. It starts at the local level, so you should be working with your direct supervisor. If that's unsatisfying, you go up your own supervisory chain, executive director, the board, if that's the process. We have procedure 1301 that describes how to do a complaint. If that is not satisfying, you have extension administration, so that would be me or Melissa Reef, and who can listen. In some cases, we'll just turn you back and ask you to please work with your executive director. And certainly a person has the ability to go to the Department of Justice, the U.S. Department of Agriculture. We would hope it doesn't get to that level. There are you can get an attorney. The ideal thing is that we work out our problems and make sure that people are getting what they need here. But it's really important to understand that people have rights. Right? If there is a research complaint within the cooperative extension system, and also if it has to do with the colleges, College of Ag and Life Science, it's Mark Schrader, who's here in Roberts Hall. Actually, I have the wrong address for him. He's up here on the 3rd floor now. If there's a problem in an extension program, so throughout the associations, those complaints would come to me. And again, the desire is always to address and fix something at the lowest possible level. So it might be the actual educator. The next level might be their supervisor or executive director. If a person's really unhappy, I'm absolutely here to listen to them and help them think through how we might address it. If it escalates to the U.S. Department of Agriculture, and I've never experienced that, but it does happen, maybe in other states, the U.S. Department of Agriculture's position on that is that they're just going to put it back to the state person, which would be me, because they really want it fixed at the local level. They have no interest in lawsuits and fines and things like that. They really want things fixed, but they're available if that's the only path. All right, there's my Justice for All poster, which was, I think I have some slide reordering to do before we record this one. So that, it's a simple poster, and the other nice thing is that it's available in dozens of languages. So you can have this section down here in almost any language that you want it. So feel free to go in. If you're working with a certain population in your community, there are certain communities in New York State where they have had some immigrants from various countries, and often people will come and sort of populate a small area in a community, and that's how they often come to the United States, and they build their own social network, and then they go out from there. So sometimes it's a really nice way to work with new populations, and we can share that information with them, right? It's important, all the things that we're talking about are sort of the laws, but really the way that it's applied is really coming out in, again, today is Title VI, so it's equal program opportunity, really looking at how all people, have an opportunity to influence the programs that we do. So that's our stakeholder meetings and your evaluations that you do in your programs, trying to get people's input. You might do a needs assessment in your community, trying to understand things and see things that you might not have seen before or with the current program participants. Making sure that people have access. This may be an ADA access. It can also be issues of access for people who might be low income. Also think about working people and having difficulty accessing our programs if they're only offered during the day. We have some pockets of programming that end up only at certain times, like Master Gardeners, because of oftentimes the volunteers. They have a very specific interest about programming at certain times of the day that are convenient to them, but sometimes it limits access for other people to come to those programs, so it's one of those places where we want to encourage broad thinking. And then thinking about how people benefit for our programs and making sure, remember those are tax dollars. We certainly get grants and contracts from other organizations, but we have lots of federal, state, and local tax dollars supporting the programs that we do, and so we want to remember that the people who are paying for these programs, we want to make sure that they have access. Right? And this applies to our programs, it applies to our collaborators, materials, communications, staff, our volunteers, our boards, and our program participants. Remember at the beginning of the presentation I was saying, we have an obligation. If we have volunteers who say, I don't work with gay people, I don't want to teach women, I don't want to teach men, I don't want to work with this or that audience. This is not consistent with our policy of non-discrimination, and we need to have a very courteous, right? It's a political environment, and again, we do survive on a lot of tax dollars and a lot of public trust, right? The public puts a tremendous amount of trust in us, so we want to address these issues in as courteous and non-confrontational way as possible, but it's really important to help our volunteers and our program participants understand everyone who is in our sphere is expected to behave in a non-discriminatory fashion. Any questions about that? And actually kind of going back to Bonnie's question before, can we be held responsible? This is a place where we actually can be held responsible. If we allow behavior to go on, if people are acting in a discriminatory fashion and we don't step in or say something, we actually could become liable for the interaction and the harm of the person who was discriminated against. So on one hand, we don't want it to happen because it's really not nice and it's inconsistent with our policy, but at the high end, it actually could create liability. Okay. So one tool that we have available to us is our Affirmative Action and Diversity and Inclusion Plan. Each association has an individualized one. Each association's board reviews it annually just to remind themselves. There were some changes this year. As I mentioned, the Office of Federal Contract Compliance laws came into play and some other laws. So there's some slight adaptations in that. It was distributed within our state in 1996, and it really is an organizational development tool. How can we look at the work that we're doing and where are our gaps as an organization and what should we be working on for the next year? So it's really a resource to associations, and it does include the laws, the expectations, the policies, and some implementation guidance and resources for associations. If anybody has questions or has difficulty getting to it, just give me a holler, but it is available on our diversity inclusion page in the organizational development unit section of the web. Right. So this is a pretty brief overview, pretty quick webinar to just discuss the basics. And so we really went quickly through basic civil rights laws, the expectation that we follow a policy of non-discrimination and that we notify the public of our obligations and their rights, like that poster is a really shorthand way to get it out there, but certainly on all of our program materials, we have our EEO statements, EPO statement. We offer equal program opportunity and we offer equal employment opportunity. There are resources available to you on the website, and you have a number of people, your supervisor, your executive director, your local HR people, your HR leads, and then your campus people, right? So if you hit a hard spot, please don't let it go. Just it's easier to address things when they're small problems than when they get to be big problems. Right, and I want to thank you for joining, and anybody that would like to stay for chats, I'm available for chat and questions. And if you are good to go, then have a great day. Try to keep warm. I promise spring is coming. And if your executive director or your supervisor, I realize we have area team people on, if you would please go back into the registration site and just note that you took the webinar, or alternatively, you can keep that information locally. But we do anticipate another federal review or audit of our civil rights compliance within the next 5 years, and that's the kind of data that they would be asking us to produce, is when was the last training. So we like to keep track of that if one way or the other. So we can do it centrally, or if you want to keep it locally, that's fine. And so I'll stop, and if you have any questions. Yeah. So if you, so Nancy is asking how would we confirm that we participated. If you would please go back into the registration site for the webinar, and you'll see that at the bottom there's actually a spot where you can record that you took it. So you're confirming that you sat through. So I know we have a couple of associations that are viewing as a group right now. And so individually people should go in. If they'd like to use the central location, just go in and check that box. So it's just like regular registration. All right, well, I'm not seeing any questions, but I will stay on. But people, please have a great day, and I will stay on for a little bit. If I see any questions pop up, I'm happy to answer them. Thank you so much. Unmuting. Anybody wants to speak up? Bye, everybody.